Hello and welcome to the Minimum Competence episode for Wednesday, March 12th, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, we cover the firing of Special Counsel Hampton Dellinger, a Columbia student's legal fight against deportation, a judge's recusal battle in a real estate antitrust case, and my column on New Jersey tax credit policy tweaks. Let's remember, only those who will risk going too far can possibly find out how far one can go and read today's legal news. On this day in legal history, March 12, 1999, the Czech Republic, Hungary, and Poland became the first former Warsaw Pact countries to join the North Atlantic Treaty Organization, or NATO. This historic moment marked a significant shift in the post-Cold War security landscape as these nations formally aligned with the Western Military Alliance nearly a decade after the collapse of the Soviet Union. Their accession symbolized a decisive break from their communist past and reinforced their commitment to democratic governance, rule of law, and collective defense. The expansion was not without controversy. Russia viewed NATO's eastward growth as a threat to its sphere of influence, deepening tensions that would continue into the 21st century. However, for the newly admitted countries, NATO membership provided critical security assurances against potential aggression, particularly given their historical experiences with Soviet domination. The accession process required extensive military and political reforms, ensuring that these nations met NATO's standards for democracy, civilian control of the military, and defense readiness. The inclusion of the Czech Republic, Hungary, and Poland set the stage for further NATO enlargement, with additional Eastern European countries joining in subsequent years. It also reinforced NATO's role as a stabilizing force in Europe during a period of geopolitical uncertainty. The decision underscored the alliance's post-Cold War mission of promoting security and democracy beyond its original Western European membership. Today, this expansion remains a key milestone in the ongoing debate over NATO's role in global security and its relationship with Russia. The removal of Special Counsel Hampton Dellinger has raised concerns about the politicization of the Office of Special Counsel, or OSC, an independent agency that protects federal whistleblowers. Dellinger, who was dismissed by President Trump without explanation, initially challenged his firing, but later withdrew his case after a federal appellate court sided with the administration. His removal highlights the administration's broader efforts to exert control over independent agencies, a move that legal experts warn could undermine their impartiality. During his tenure, Dellinger was an advocate for federal workers, helping reinstate over 5,000 Department of Agriculture employees who were improperly fired. His dismissal is expected to weaken the OSC's role in protecting workers from political retaliation. Legal scholars suggest that unless the Supreme Court intervenes, the precedent set by his firing could give future presidents greater authority over independent agencies. The case also ties into a broader legal battle over presidential power, as courts are reviewing Trump's terminations of other agency officials, including members of the National Labor Relations Board and the Equal Employment Opportunity Commission. While Dellinger had legal grounds to challenge his firing, he strategically chose not to pursue the case, allowing stronger challenges, such as that of NLRB member Gwyn Wilcox, to take precedence. The legal debate is moving toward a potential Supreme Court review of the case Humphreys Executor v. United States, a 1935 decision that limits the president's power to remove independent agency officials. If overturned, the ruling could significantly expand presidential authority over such agencies. A U.S. judge will hold a hearing on Columbia University student Mahmoud Khalil's challenge to his arrest by immigration authorities, a case that has sparked protests and political debate. Khalil, a Palestinian student and U.S. permanent resident, was arrested outside his university residence by Homeland Security agents. The Trump administration has accused him, without providing any evidence whatsoever, of supporting Hamas, though Khalil has not been charged with any crime. Judge Jesse Furman was temporarily blocked Khalil's deportation and may order his release if his rights were violated. However, an immigration court, not Furman, would ultimately decide whether Khalil can be deported, a process that could take years. Khalil's lawyers argue that his arrest is political retaliation for his pro-Palestinian activism and violates his First Amendment rights. His detention in Louisiana has limited his legal access, and his wife, who is 8 months pregnant, has spoken out against his treatment. The case raises broader legal questions about the intersection of free speech and immigration law, particularly as Trump has vowed to deport foreign students involved in pro-Palestinian protests. Khalil's arrest has triggered demonstrations and condemnation from Democratic lawmakers who view it as political repression. A major real estate brokerage, Howard Hanna Real Estate Services, has asked a U.S. judge in Missouri to recuse himself from an antitrust lawsuit due to political donations made to his wife's campaign by the plaintiff's lawyers. The lawsuit accuses brokerages of conspiring to inflate real estate commissions, and plaintiffs have already won significant settlements in related cases. Howard Hanna argues that the donations create an appearance of impropriety, requiring Judge Stephen Bowe's recusal under ethics rules. Bowe had previously disclosed the donations and offered to step down in an earlier case, but no party requested his removal at the time. Plaintiff's lawyer Michael Ketchmark dismissed the recusal request as meritless and a delay tactic after Howard Hanna had lost key motions. Bo's courtroom previously hosted a landmark jury verdict in a related antitrust case, leading to over $1 billion in settlements with brokerages and the National Association of Realtors. The judge's decision on whether to step aside could impact the trajectory of ongoing real estate antitrust litigation. And my column this week touches on New Jersey tax credits. New Jersey is poised to increase its Angel Investor Tax Credit, or AITC, from 20% to 35% of investment costs with a $35 million annual cap. Given the limited funds, ensuring the credit is effectively allocated is essential. However, the proposed bill includes carbon footprint reduction technology as an eligible category, which could allow carbon capture projects to qualify. Critics and I argue that carbon capture is neither emerging nor effective. It's costly, inefficient, and largely benefits fossil fuel companies by prolonging their operations rather than reducing emissions. Instead of funding speculative or ineffective technologies, the state should prioritize investments in proven decarbonization strategies like renewable energy, battery storage, and energy efficiency improvements. These sectors have demonstrated cost savings, emissions reductions, and job creation without the need for indefinite subsidies. Tightening the AITC eligibility criteria would prevent resources from being diverted to projects with questionable climate benefits. By refining its definition of eligible technologies, New Jersey can maximize the impact of its tax credit, ensuring funds support tangible climate and economic progress. States that design smart, targeted incentives will attract startups and clean energy investments, while those that fund vague or ineffective projects risk falling behind. As federal climate incentives remain uncertain, state policies will play a crucial role in shaping the future of clean energy investment. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, if you aren't in over your head, how do you know how tall you are?